Okay, guys, welcome back. Tonight we're having the emergency team meeting. I know last week I said we're going to talk about the other document that Ryan sent us, but we're going to talk about some other stuff today. Hang on a second here. Got to give myself a thumbs up because I'm sure I'm going to like what I got to say today. We had one of our team members go to file her jurisdictional challenge with an affidavit. The clerk gave her a really hard time. As a matter of fact, the clerk whited out the attorney that she had named as the number one defendant. The clerk whited it out and was not letting it, actually would not let her file it. I think some of that could probably have been avoided if we had had time to watch the videos and learn all of the things that you need to say when they're giving you a hard time. But nonetheless, they gave her a hard time. And that's kind of what we're going to talk about tonight. And we're also going to go over a couple of documents that people have in their paperwork that they could be using, and they need to understand what these documents are. We're going to just go ahead and get started. Oh, before we get started, you guys, if this is your first time, click the bell down below, subscribe and click the bell so you get notification when it's time for class to start, so you don't be late. And if you're late, you're going to have to run. So, well, you won't have to run. You'll have to run a lap to the refrigerator, get some more beer or something, whatever it is you do there. So let's get started. The first thing that you guys need to learn is the filing statutes for your state. You need to find out where that filing statute is for your state, and you need to include that in your document. I would include it on the first three lines so they can see when they look at it that you know what the filing requirement is. Because at the end of the day, that filing requirement has, if you look at it, you'll see it's very liberal. It don't have you jumping through none of the hoops that they try to make you do. And what they're doing to you is forcing you to follow the local rules, and the local rules are set up by the court, by the bar members, to for the attorneys. And in my opinion, these local rules are set up to speed the process up. So anytime your process is getting sped up through court, you're getting hosed. That's plain and simple. Okay, and the problem with the local rules is they have not been through the legislative process to be binding on to be legally binding on anybody. That's the problem. Now, when they start giving you a hard time, if you don't know any of this, you don't know what to say. It's imperative that you learn the document and watch the videos so you understand what you need to say about the document when they're giving you a hard time. Most folks have no idea the effort that it takes to fight the corruption in your illegal foreclosure. I'll tell you this. You guys can talk to Shamel Maxwell. She's in the foreclosure rescue group, and she has blocked the sale of her dad's house like 4 times. They just kept trying to, yeah. She's been all over it, and they actually were going to evict him on, I don't know, the first of this month or the last of last month or something, and he's still in his house right now. She amended her lawsuit and she filed it in federal court. Well, she stated a claim for relief. She looked at the video, that which is the second subject of tonight's stream, and we're going to go over that, how to state a claim for relief and all that. The video is posted for you guys to look at. Also in the video is a guide to stating a claim for relief you can print off and just have laying on the table with you while you're writing it out. One of the things I wanted to say too is if they're refusing to file your jurisdictional challenge with an affidavit, then you can take it. And this is what I suggested to the team member. I suggested that she file it in another county over, and tell them that, I ran out of gas, I can't make it any further, I got to get this file today so that it gets, so maybe can you guys just file it here and then shoot it over to them in an email so they can post it on the site. And when you do that, that blocks them from being able to remove it, because they didn't file it, they can't remove it, and they don't have, they can't call them over there and tell them to remove it and explain to them why. So that, and the other thing too, you can just take the word attorney off of it and just leave the attorney's name, because at the end of the day, you're suing the dude or the woman. You're suing the woman or the dude, whoever is the attorney. You're not suing their corporation. Well, actually, you are. You're dragging their law firm in. But the only reason you add the law firm is to prevent anybody from a law firm from helping them. Because I wouldn't. If you're suing their attorney for 5.5 million, I think that's enough. You don't even have to worry about the law firm. The idea is to keep this as simple as possible, and to make it a total pain in the butt for them. So most folks have no idea the amount of effort it takes to fight the corruption in illegal foreclosure case. And most folks don't realize that there are two issues here. There's the issue of the unlawful mortgage loan, and then there's the issue of the fraudulent foreclosure. And when you argue the foreclosure and you talk about the mortgage loan, you're screwed. Okay, you're just shooting yourself in the foot. Okay, because you're going after the wrong person. And that's the same thing when you learn that the lender is not the one coming after you. The lender don't have nothing to do with the foreclosure. Yeah, the foreclosure is done by third-party debt collectors, and that's who's coming after you. And when you figure that out, you will be driver of the bus, I'm telling you. And that's what we do here. When you take my documents to the court, they should be able to be filed, and then there shouldn't even be a hearing because my stuff is fire. I spent a lot of time researching and putting this stuff together. And the fact that they don't want to file it shows right there that it's badass. I mean, I'm just saying, why wouldn't they want to file it and let the judge figure it out? Well, they know you're jamming up their attorney friend and they're trying to help. And the person that was giving this team member a hard time probably was the wife of the attorney. You never know. You never know. That shit is everywhere. You just never know. Jamel Maxwell, we were talking one day and I asked her, so how many times does she think she called down there to talk to the clerk about this crap they were pulling? Because they tried to lose her shit at one point, but she was smart enough to follow the instructions. And when she mailed it to them, she made them sign for it. So they signed for it, and then the next day tried to say that it was lost while they go hurry up and sold her dad's house. Well, we already kind of knew what they were going to do, and we had another document ready. She went down and amended it and added the clerk's name who signed to the lawsuit, because that clerk is responsible for filing that shit the same day he picks it up. Yeah, so all of a sudden they found it. Mm-hmm. Yeah, that's what I'm talking about. So you guys should talk to Shamel, message her or something, and find out what she's gone through to give you an idea of what it takes. Because most people do not spend the time that's needed, and I'm just throwing it out there. And most people do not spend the time that's needed. And some people who are used to having attorneys working for them, those people struggle too because they're not used to doing everything. And in this program, you have to, especially when you already know that having the attorney help you is not going to work for you in the end. Because here's how this goes with them: the attorney is the one that's suing you for your trying to steal your property. Okay, other attorneys are not going to attack him. And this is how this goes. When one attorney is suing you and you hire another attorney to defend you, that attorney that's defending you automatically gets a cut of the pie, what they're taking from you to throw you under the bus, in addition to the money that he's taking out of your bank, pretending that he's helping you. Sad, but that's the way it goes. I work with people from all across the United States of America in our private Facebook group. And that's what I see. I get real time feedback on how these fools are trying to get out of doing stuff. And so it allows us to take advantage of it. Now, what I do, and this is what I'm suggesting you do, okay? If the clerk is blocking me from filing my stuff, telling me a bunch of crap, then I'm going to learn everything that I need to know about the clerk's job, about what the clerk is supposed to do, where the clerk gets the authority from, what limitations the clerk has, what authorizations the clerk. I want to know everything about the clerk. Otherwise, how can you jam them up for screwing you over? Okay. When you get on the internet, and I tell people, well, when you get something from the court, get on Google and research it before you call me up all maxed out, because their whole process is fraud. And if you do your homework, you won't have no trouble picking it apart. So that's what you have to do. You have to figure out what they're supposed to be doing, what their limitations are, and when they're stepping over those limitations. And who you need to complain to about that. And it's not the Bar Association, because they don't give a shit about anything. I'm telling you, you're wasting your time filing a complaint with the Bar Association. That's not in my instructions anywhere. So if you're in the non-conventional program, which is what I have set up here, then you're not going to waste your time filing. You're going to spend that time getting your lawsuit, getting your title dispute filed in federal court. You're going to spend that time going over the videos and stuff. You know, I have sometimes people get in my program and they consider my documents to be the same as normal documents or whatever. I'll just fill them out and take them down there. And no, that's not how this goes. My documents, they don't want to file. They don't want to deal with, and they help each other all day long. So you're going to need to get on the instructional videos, and you're going to need to watch those videos and figure out what documents you're supposed to use. You're going to need to figure out how to use the documents, what the strategy is for each document. And believe me, there's a bunch of documents in it. Someone emailed me today maxed out because of all the documents, and they told me that I need to make it more clear. And I was like, dude, I'm the only one here doing this. Okay. I'm doing the best that I can. You got what I have. If you watch the videos, you'll have an idea what you're supposed to be doing. If you don't watch the videos, you won't have any idea what you're supposed to be doing. And it's going to make it really complicated for you, because if you go to the table without knowing what you're doing, then they're already going to disrespect you. And then they're going to treat you like crap. And then you're going to have a huge mountain to climb to earn their respect. And the only way to do that is to hold them fools responsible for what they're trying to do. So if they did that to me, I would probably, if I waited till the last minute to file my stuff, I would go to a county over and file it and have them send it over and give them some big story about how my car just ran out of gas and I can't make it to over there, and have them file it and shoot it over to them and just thank you so much. Okay, now you could get it on the record. After you get it on the record, that person that was doing all that stuff, I would handle that person real quick. And when I say handle them, you're going to figure out what that is, because I can tell you. But if you don't figure it out and go to the table with it in your mind that this is getting done, then they'll turn you away again and tell you that you're crazy. And believe me, I've had them tell people that my documents are not factual. One guy told me that they told him that my documents were not factual because attorneys have a license. And I was like, okay, I don't even want to hear the rest of what you got to say. Okay, because we're done here. If you believe what they say and you believe what the bar members tell you, then you probably shouldn't be in my program, because it's just not going to work for you. Because I don't have time to redo my homework again to convince people of this or that. If you don't believe what I'm saying, then do your homework. If you don't have time to do your homework, you need to get your shit filed to protect your property, and then do your homework later. At some point, you're going to have to trust somebody. And if you understand the reason why I'm here, I'm a pretty good person to trust, because I already tell you, I don't like attorneys. There, I said it. Sometimes people freak out when I say I hate attorneys. Hate's a pretty strong word. Well, it fits pretty well, but I'm trying to be nice too. So when you learn the clerk's authority, you'll find out that the clerk is probably using the local rules to violate you. Uh-huh. The local rules are for attorneys to use to speed up their stuff through court. Yep. At the end of the day, you want to sue whoever is blocking you from achieving your goal. I don't care if it's the judge, if it's in my program, what you will be doing is building the court record that you need to sue the judge when the judge finally violates you, to allow attorneys a free pass, because they're not getting by my stuff, not on the merits. They don't even want to argue it. The judge has helped them. When you come to the table with the jurisdictional challenge with an affidavit, they can't argue it. And they certainly can't sign a counter affidavit because they're lying. So right out the gate, by attaching a counter affidavit to it, you're screwing up their whole program. And then when you add the attorneys as the number one defendant and the law firm second, that causes a bunch of problems too. What you need to make sure that you're not doing is don't freak out when the clerk is violating you. Oh, you can't file that. That's ridiculous. You can't file the attorney. The attorney is, you need to put the homeowner association on there. Well, wait a minute. The homeowner association didn't sign nothing here. And my legal team told me that this is what I need to do. So if you're telling me that this is wrong, are you giving me legal advice? Because if you are, I'm going to have to let them know because they told me that you guys are not allowed to give out legal advice. All you're allowed to do is file the correspondence and let the judge figure out what needs to be done with it if that's a problem. And if they give you a hard time, what I would do is ask them, the supervisor, do you have the authority to make a legal determination on my document? I did not think the clerk had the legal authority to make a determination on my document, but I could be wrong. So please let me know. And if you do, please let me know where the statute is that gives you the authority to do that, because my legal team is going to want to know. And by the way, what's your name or your employee number or whatever? Because my legal team is going to want to know that too, because my legal team is going to make sure that we hold anybody accountable that's blocking me and helping the attorneys injure me by stealing my house. So I just want to make sure that's on the record. Now, you need to make sure that you don't let them see you sweat. If they think your document shit, play it off. Play it off. Don't agree with anything that they say, ever. Play it off. And if you got the document from me, then you know they're lying. The best way to tell when an attorney's lying or bar member's lying is hit their mouths moving. So that's it. If you got the document from me, don't even worry about whether or not it should be real or whatever, because what I put together is what I am using for my family and what I have used for myself. I already know they're going to tell you all. They've told people that my stuff is copy and pasted. My stuff is sovereign. I'm a Moor and all of this stuff. And I'm not a Moor. I'm not sovereign. I'm a state citizen of the Republic State of Arizona, where I was born. I'm not a U.S. citizen. Nobody can be a U.S. citizen because nobody can be born in a fictitious entity, in a fake corporation. Nobody can be born in a fake corporation because nobody can be a U.S. citizen. Okay, we're all born somewhere, and it wasn't in the fake citizenship thing that they try to. Okay, I'll move on. So here's the deal: when you go into court, those clerks are so nice and sweet, and they come over to you and they give you this legal advice, and that's the best way to shut them up. Are you giving me legal advice? But here's the deal with them: if they smell fear, they're like vultures. They can smell your fear a mile away, and once they smell your fear or see the expression on your face that possibly you could have a document that shit, and yeah, well, you see where I'm going. You see where I'm going with this. Once they see that, you're done. They're gonna give you the runaround like hell, and you're gonna have a steep hill to climb to earn their respect. Now, rolling with us is not gonna be that hard. If you have done your homework, you will see that you got documented for sanctions. You can file sanctions against the clerk. You can do all kind of stuff. Okay, there's no limitations in my program. There's no limitations. What you have to do is spend that time researching. You research what their responsibilities are and how they're screwing up. And then you use that to take advantage of the situation. I put together a new document that I'm going to send you guys a link to dismiss foreclosure in state court. And what I'm doing is I'm putting together a series of documents to help control the situation in state court. We need to control the state court situation better. So I'm putting together some documents to help you do that. Well, some people are going to look at that and say, oh, $50, oh, what the hell? Okay. So those people don't know how to roll, because it ain't about that. Think about this. If I make this where everybody can afford it, if half of the people that need this bought it, yeah, I would not miss a meal. So, so my point, I guess, is you don't need to ask $5,000 for something. Okay. Because when you do that, nobody can afford it, because the people that need it don't have $5,000. So I obviously didn't get in this program for the money, but I do have to eat, and we're getting it figured out. We're getting it figured out. Now, the new online course that I put together, I structured it for property owners and property investors who invested in rental properties and are worried about losing those properties because of the pandemic. And when the pandemic started, I mean, if you have rental property and your tenants have never been late or never missed a payment, and all of a sudden they don't have a job, there's not, you really can't do anything to them. You need to figure out what you're going to do to protect your property and to make sure that the attorney can't steal it from you. And so that's what this this online course has everything. And the online course has upgraded documents. I don't know, 24 people in the course already, and I haven't heard much from anybody, hardly. And that's a good sign, because that means things are going smooth and they got them back on their heels, and they're trying to decide how they're going to get off money that butt whooping that they're getting. Okay, so I want to get moving here so I don't spend too much time. Next, we're going to talk a little bit about staying a claim, and we're going to go over that. So we're going to go ahead and let me see what the time is here so that I can mark this. Okay, so let's get on with the second subject here, stating a claim for relief. Now, I know some people bought my package, and when they got jammed up for stating a claim for relief, I had one guy call me, and he was kind of concerned that, my document wasn't any good, and I had to explain to him that, look, they're going to try and block you from filing it, period. End of the story. Okay. If they're giving you this much of a hard time, then that doesn't mean the document is not good, because what you have is not a conventional document that was prepared by an attorney. Okay. So they don't like to have stuff that's prepared by pro se people or paralegals like me who don't like attorneys. Okay. Because they don't want to address that stuff, and they know the attorney can't. So they always use Rule 12B to try and dismiss your stuff. That's all. That's just automatically what they do. I never worry too much about it because I have enough stuff in my documents to where it should pass this easy. But people don't understand what they need to argue to get past it, and they freak out. So I decided one day, the reason I didn't do it already is because I ain't trying to follow none of their shit. Okay, I have my own thing and do my own stuff. I go full wheeling across the country and over there. So when you follow their path, okay, they have it set up to take pot shots at you the whole time. So I don't follow the path. But I decided at this point to follow it because, there was like 3 or 4 people that were having this problem. So we're just going to take care of the problem, and what the hell. So I spent a week and a half, actually about a week or so, studying this and putting together the presentation so I could explain it to you guys. So Rule 12B is part of the Federal Rules of Civil Procedure. The Federal Rules of Civil Procedure is where you're supposed to go to learn what the rules are for what you need to do. If you need to serve a process on them, you go to Federal Rules of Civil Procedure, see what the process of service is. Or for process service, you might even look up what the rules for your state, what the process of service is for your state. But for filing pleadings and answering and things like that, all is done under Federal Rules of Civil Procedure. Now, here's something interesting. When you get into state court, they want you to follow a different set of rules. So wait a minute. Why is it that the state court is trying to make you follow local rules? Oh, wait, the state court is also supposed to be following the Federal Rules of Civil Procedure. And this is why I always use federal court case law whenever I have to file something in state court. I use federal court case law, and I have the case law that supports the fact that you can use federal case law in state court, as well as Supreme Court case law in federal court and state court, because federal court's a higher court. Attorneys hate it, and they whine about it. Judges don't like it because it forces them to follow precedents that they don't follow, and you can sue them later. Well, that's another story. You need to make sure that you're following the Federal Rules of Civil Procedure. And the Federal Rules of Civil Procedure 12B, which states in part, in general, that defenses should be put in the defendant's answers. But it also gives the defendant an option to raise some defenses by motion before answering. Now, challenging jurisdiction can be done at any time. So you can challenge jurisdiction you don't have to answer. My answer to them would be my challenge to jurisdiction, or the jurisdictional challenge with an affidavit. That's one badass document. That's what I was sticking in their face. You don't have to answer them. You don't have to play their game. And if you answer to what they want, you're going to be fried. Okay, you're going to be toast. That's it. You can't do that. So you need to challenge the jurisdiction instead of answering. Okay. So therefore, the defendant can, instead of answering right away, can raise motions on Rule 12B motion, but only if the defendant loses that motion, will they have to file an answer to the complaint. So the defendant, when you file your lawsuit against the attorneys, the defendant will use the Rule 12B to try and raise a motion and defense out of Rule 12B6. Failure to state a claim for release can be granted. Most people freak out and they run around, and somebody that's actually doing pretty well in the group made a comment today that they're going to get hosed. Well, you're only going to get hosed if you don't spend the time to learn how to state a claim for relief and redo it. Now, I understand that people have to work, to have 2 jobs and all of that, but I also understand that you don't want to be packing your shit up out of the front yard in the rain. You need to make time to watch that video and make the changes to the thing. As a coach, I don't even want to hear that other stuff. Okay. I had this and that happen, as a coach, we don't care. Coaches don't care about none of that stuff. The job's got to get done. That's it. So let's start. What is a claim? In order for a defendant in a motion to dismiss or failure to state a claim for relief can be granted, you first need to understand what is a claim under the Federal Rules of Civil Procedure. A claim for relief is defined in Rule 8A as having 3 elements: a short and plain statement of the grounds that provide jurisdiction to the court, a short and plain statement of the claim showing that the pleader is entitled to relief, and a demand for judgment for the relief the pleader seeks. Now, what this means is that the complaint needs to contain statements that support the federal court's jurisdiction. For example, this case is brought before the court under constitutional rights under 42 U.S.C. section 1983, allegations of fact that support each claim that's being made, and request for relief. The policy behind these rules is to simplify the pleadings and not put up technical barriers to relief. Now, when I started studying this, one of the things that I came across that I thought was like, holy crap, this is pretty freaking easy. Now, I should have done this a long time ago. Nonetheless, we're doing it now. The most important part of Rule 8A is the purpose of a Rule 12B6 motion is the second part, the short and plain statement of the claim. A short and plain statement of the claim. That's important. And I have a guide to guide you through that. This means a short and plain statement of the facts that make up the claim. For example, you must put in statements that show what happened to you, that you were seriously injured, and the mental state element required by the court, that the defendants acted with deliberate indifference to the Constitution or the federal law, or the Constitution and federal law. This last one, C, is the one that most people miss out on. Well, most people miss out on all of them because we don't do that. But C is the one they don't mention when they're picking your shit apart. They mention all of the other stuff. You didn't state a claim, you didn't do this, you didn't do that. So people run and state their claim. Instead of looking it up, they just respond to the document and state their claim and all of that, but they don't do C because the attorneys never mention that you failed to state the mental requirements by the court. They intentionally leave that out so that they can still move to dismiss your shit. If you fail to state the deliberate indifference in your complaint, it will be dismissed for failure to state a claim, a constitutional claim. You must make sure specific allegations of fact, who did what, where, and when. Avoid conclusions. Also, be sure to include how you were injured and by what the defendant did, how you're injured by what the defendant did. After putting the factual allegations in, you can say something like, these facts show the defendant violated the plaintiff's constitutional rights and the real estate deed laws, etc. And when I say real estate deed laws, the whole foreclosure scheme started with violation of real estate deed laws. So real estate deed laws mandate that your deed be delivered to you after the sale, but that's not what happens. Okay, they trick you and tell you that it needs to be registered in their office. So they do what they call a constructive delivery, and they register your deed in the office. And that registration of the deed in their office is what initiates all of the problems that you're having now. It initiates the property taxes, the zoning, coding, and for code enforcement, all of that. And this is one thing that people don't realize either. So once they get your deed registered in the office, the first fake lien that's put against your property is the mortgage lien. And I have fools in the page on Facebook, attorneys. You can tell when an attorney comes up to attack me because they're like vicious, angry. They're like mad as hell. Most people are like, damn, I love this. Oh, not the attorneys. So when the attorney get up in my face, usually what I tell them is, okay, so the whole foreclosure, the whole law goes, register your deed in there, it's all fraud. No, okay. So let me ask you something. If there are several owners of property before a lien can be placed on that property, all of the owners would have to be present to sign, right? Well, yes. So when the bank accepted your signature on the mortgage lien against your property, the bank knew you owned the property free and clear, or they would not have been able to accept your signature on it. Bam. Yeah. Keeping it simple. Now, people don't realize that your signature was actually what generated the electronic credits that they're saying was a loan. And we're going to talk about that before this is over with today too. So I got a couple of other documents I want to show you and explain how that shit works. So if you have included in your complaint the jurisdictional allegation, the facts of what the defendants did, allegations of deliberate indifference or other necessary mental states, and a request for relief, monetary damages or injunctive relief, then you have a claim. So the standard for Rule 12B motions, courts do not generally favor Rule 12B motion to dismiss because of the policy of the federal rules to allow cases to proceed if the plaintiff has a reasonable chance of obtaining relief, or if you're filing my stuff. Yeah, that's it. Or you're filing my stuff because they don't like my stuff. So therefore, the defendants are required to make a strong showing before the complaint will be dismissed for a failure to state a claim. Now, if the complaint is dismissed, it has to be dismissed without prejudice. They can't dismiss your case with prejudice for want of form. Well, they can try, but it's illegal. It's a problem for them. So Rule 12B motion argues that based on what is said in the complaint, the plaintiff could not possibly be entitled for relief. Now, for most people, the biggest problem that they have with this is they have the wrong person listed as the number one defendant, because most people list the lender as the number one defendant because the attorney told them the lender was the one suing you. So you put the lender down, and the attorneys laugh all day long because they all know that your stuff's going to get kicked out of court when they get done making you pay for hearings and stuff for failure to state a claim for relief, because you don't even have the right person. The person you have is a lender, and the lender is in charge of the mortgage fraud, not the foreclosure. So what we talked about in the beginning. It's two whole entirely separate situations. If you hold the wrong person accountable for the wrong shit, then you're going to be in trouble. Courts do not determine whether the facts stated by the plaintiffs are true. Instead, assume the truth of the plaintiff's factual statements and decide whether you may have a claim that could lead to relief. So the U.S. Supreme Court has stated the issue is not whether the plaintiff ultimately prevails, but whether the claimant is entitled to offer evidence in support of the claim. That whole little sentence there would be what I would use. I want to make sure that you put that in, if you ever have this problem, that you sum it up and have that in there somewhere, that you are entitled to offer evidence in support of your claim based off of what you put on the table. So a complaint should not be dismissed for failure to state a claim unless it appears beyond a doubt that the plaintiff can't prove no set of rules or facts in support of the claim that will entitle him to relief. Conley versus Gibson. Now, these case laws I have in the guide, so you can use them too. Dismissal without leave to amend is improper unless it is clear upon novo review that the complaint should not be cannot be saved by an amendment, which to me is ridiculous because you should have a chance to amend it even if you can't get it right. Don't get it right the first time. But so important points to consider. First, Rule 12B motion should not be included in any additional factual material by the defendant. So if you're facing this problem, the defendants cannot include any additional information that's not already on the court record. And if the defendants do attempt to add facts, and this is important, it is likely that the motion will be treated as a Rule 12B6 motion. It's not likely that it's going to be be treated as a Rule 12B6 motion, but as a motion for summary judgment. So if they add additional facts, if the defendants add additional facts, then it's likely that they're turning the motion into some motion for summary judgment. And if you have this happen to you in court, then what they do is they use this to trick you to throw people under the bus in court because you show up ready to argue the wrong stuff and they switched it. And if that happens to you, then all you need to do is move the court for a continuance so that you can have the time that you need to respond. So this means that in deciding the Rule 12B6 motion against the pro se plaintiff, the court is supposed to look at even more carefully to see whether any set of facts consistent with the complaint could be proven, and if so, to deny the Rule 12B6 motion. So when they file that, it's not the end of the program, and you have the video that you need to redo that so that you can amend your motion and put what you need in it. And the online course has this all wrapped up. So I already put the document that you need to copy and paste. So if you are in the online course, you won't need to worry too much about this. Now, I put everything in there too. So if you guys have a team of foreclosure specialists that are going to be handling your stuff, then they'll need to know how to do this from scratch, which is the goal. Because in this program, you're going to learn how to do it yourself without an attorney in your face or without me in your face. Okay, sorry. I got carried away with the face stuff. So motion for summary judgment is governed by Rule 56 of the Federal Rules of Civil Procedure. So whenever they file a motion on you for something, look it up on the Federal Rules of Civil Procedure. It explains everything that they're supposed to be doing and explains what you're supposed to be doing and how you're supposed to, it explains everything. And half the time you'll find out that they're full of crap.